Of experts.
Isn't there a larger question before us? Is the state segregation law constitutional?
No, I think we ought to hear this evidence. Mr. Marshall, you may continue with your witnesses.
I am a social psychologist and educator. I have degrees from Howard University and Columbia.
Is it true you conducted scientific measurements in Clarendon County to determine the effect of segregation on Negro school children?
Yes.
I can't hear the man.
Speak up, Mr. Clark. Please describe, Dr. Clark, the results of your investigation.
When Negro children were asked to choose between the white dolls and the brown dolls, and to say which doll was the nice doll, 65% said the white doll was the nice doll. Every one of our tests shows an unmistakable preference for the white doll and a rejection of the brown doll. These children in Clarendon County, like other human beings who've been subjected to an obviously inferior status, have been irreparably harmed. The result is a confusion in the child's concept of his own self-esteem. This leads to a desire to resolve this basic conflict by withdrawing.
Do you believe this policy of segregation has any effect on the white children?
Yes. It causes moral confusion. The child who is part of the segregating group sees the same people who teach him democracy, brotherhood, the love of his fellow man, also teach him to segregate and discriminate.
Your witness, Mr. Tully.
Dr. Clark, how many white children were in your classroom when you went to school?
None.
Has anyone ever described you as inferior? No more questions.
Legal segregation of education is the single strongest factor in causing harmful effects on the physical, emotional, and financial status of the Negro child. How does this happen, Dr. Bates?
Over so long a period, segregation is legal in education, so long as it's equal. Mr. Tully, you have come here and admitted the facilities are not equal. The law does call for equality, does it not? Isn't the surest way to achieve equality to admit the colored children to the superior white schools?
No, sir. The problems of race, if Your Honor pleases, will not be solved by force, but rather by the slow process of community experience and mutual goodwill. And any ruling by this court must take into account the fact that school facilities cannot be built overnight. All we're asking is time.
There is no factual dispute before this court. Negro schools are conceded to be unequal. What is at issue is the law. Yes. Separate but equal has been the law of the land for many years, but the Supreme Court has ended segregation in Southern graduate schools without any negative consequences. This is progressive development of the law. In South Carolina, all the state officials are white. All the school officials are white. This is not just segregation. This is exclusion from the group that runs everything. The Negro child is made to go to an inferior school. He is branded in his own mind as inferior. which sets up in his mind a roadblock that prevents him from ever feeling he is equal. You can teach such a child citizenship. You can teach such a child the Constitution. But he knows that for him it isn't true. Your Honor, we have shown that lasting damage is done to Negro children every day that Clarendon County operates its school system in violation of the law. The defense asks for time. Time for the slow process of community experience. I know of no statute that allows anyone to walk into court and ask for time to stop doing something which is unlawful. If the Negro children of Clarendon County are entitled to any rights as American citizens, they are entitled to those rights now, not at some time in the future. Now is the time for the court to act.
States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are invited to draw near and give their attention, for the court is now sitting. God save the United States and this Honorable Court.
Case number 101, Henry Briggs Jr. et al. Against members of trustees of School District number 22, Clarendon County, South Carolina, et al.
Counsel are present.
Mr. Marshall.
Mr. Chief Justice. May it please the court, my colleagues will address the Kansas, Delaware, Virginia, and District of Columbia cases. I will speak on behalf of Harry Briggs Jr. and the Negro children of the town of Somerton, who have raised their attack on the validity of the South Carolina Code, which reads, "It shall be unlawful for pupils of one race to attend the schools provided for persons of another race." In the lower courts, we produced unchallenged experts who testified that segregation damages the personality of Negro children and destroys their self-respect. If Ralph Bunche, this nation's distinguished ambassador to the United Nations, were assigned to South Carolina, it would be the will of the people that his children go to a Jim Crow school. No matter how great anyone becomes, if he happens to be a Negro, his children are relegated to that school. Yet this court is being asked by the defense to uphold the segregation law of South Carolina. Under our form of government, the only testing ground as to whether or not individual rights are violated by the majority is here in this, the Supreme Court of the United States. The court must weigh the rights of the Negro children against the public policy of the state of South Carolina. And if that policy violates those rights, then this court, reluctant or otherwise, is obliged to say that that policy has run up against the 14th Amendment to the Constitution, which guarantees all citizens equal treatment under the law. We therefore respectfully urge that the judgment of the district court be reversed and the children's rights be affirmed.
Is it fair to say that the South Carolina legislature set up segregated schools to avoid racial friction?
Yes, sir.
Doesn't the legislature have to weigh the advantage of maintaining law and order against what might be a disadvantage to the segregated group?
I think that the legislature should, Mr. Justice Reed, but I think we have to bear in mind that, as far as I know, in these states, there is not a single Negro legislator doing the weighing. The only point before this court is the law as it was applied in Clarendon County. All we are asking is that the state-imposed racial segregation be stopped and that the county school board be instructed to work out a solution.
What kind of a solution?
They could assign children to schools on any reasonable basis.
You mean we would have gerrymandering of school districts?
Not gerrymandering, Mr. Justice Frankfurter. The new district lines would simply have to be drawn on a natural basis without regard to race or color.
It would be important to me to have you spell out exactly what would happen if this court reverses and the case goes back to South Carolina.
What is important is that we get the principle established. Segregation by race is not legal. It is impossible right now to say precisely how it will work.
I think it's important to know before one starts out where he is going.
I would like to reserve the remainder of my time.
We have the uncontradicted testimony of expert witnesses that segregation is hurtful to the children of both the colored and the white races. Now, there are experts, and there are experts. Let me read a sentence or two from W.E.B. Du Bois, the great Negro educator. I have seen wise and loving colored parents take infinite pains to force their little children into schools where the white children and white teachers despise and bully the dark child. Now, such parents want their children to fight this thing out, but dear God, at what a cost. Dr. Du Bois concludes, we shall do better by putting the children in schools where they are wanted than by thrusting them into hells where they are ridiculed and hated. Let me come now to what is the crux of this case. That is the meaning and interpretation of the 14th Amendment to the Constitution of the United States. Your Honors have said it is your duty, and I quote, to place ourselves as nearly as possible in the condition of the men who framed the instrument. Now, what was the condition of those who framed the instrument? I will tell you. The resolution proposing the 14th Amendment was prompted by Congress in June of 1866. 1 month later, the same Congress established separate schools for the races right here in the District of Columbia. And from that good day to this, Congress has not wavered in that policy. So clearly the Congress does not believe that the Constitution speaks against segregated schools.
What is your answer, Mr. Davis, to the suggestion that the Constitution is a living document, must be interpreted in relation to the facts at the time it is interpreted?
My answer to that, Mr. Justice Douglas, is that changed conditions do not expand the language that the framers of the Constitution employed. And it is inconceivable that the Congress which passed the 14th Amendment would have forbidden the states to employ an educational plan which Congress itself was employing in the District of Columbia. No court, I respectfully submit, is justified in ignoring that. And over the years, this court has spoken in the most clear and unmistakable terms to the effect that segregation is not unlawful. In Plessy v. Ferguson, and in 6 subsequent cases, The doctrine of separate but equal has been upheld. So, Your Honors, I might ask, why should this be a matter of great national policy? Is it not a fact that the very strength and fiber of our federal system is local self-government? I respectfully submit there is no reason why this court or any other should reverse the findings of 90 years.